Welcome, Hillmantok students, to Class 8. Today we're going to be looking at the intersection of AAVE and the legal system. Our journey is going to look at how biases against its speakers can impact legal proceedings. We're going to explore real-life case studies that highlight these challenges and discuss some theoretical frameworks that can be used to address linguistic bias. Additionally, we'll look at some recent policy reforms and training initiatives aimed at promoting fairness or eradicating it. And by the end of our session, you'll have a deeper understanding and appreciation for the importance of linguistic awareness in ensuring justice for all. As we do in most classes, I'll give you a moment to familiarize yourself with some key terms that are central to our discussion. This definitions list is not very exhaustive, but it is a good place to start to ensure that we all have a similar place of understanding as we begin. If you need any further clarification on any terms, feel free to reach out via email, in the YouTube comments, TikTok comments. Our discussion is going to be structured into three main parts. This is our lesson map. So first we'll begin by examining how linguistic bias, particularly against non-standard dialects such as AAVE, lead to misunderstandings in legal contexts. These biases influence how attorneys and judges express themselves, analyze and construct arguments, and then ultimately make legal decisions that affect lives. We're going to delve into, some of the challenges that reporters face on transcription, when transcribing non-standard dialects that then lead to inaccurate court reporting. Testimonies are misinterpreted that'll affect potentially jury deliberation and appellate review. These pose significant barriers to the due process for speakers of these dialects. Finally, we're going to explore how these misunderstandings of linguistic nuance create ambiguous legal interpretations. So, then infringements upon the legal rights, linguistic profiling, where an identity or individual is identified based on ethnicity, based on auditory cues that influence their legal proceedings, their employment opportunities, education. We've spoke about it, in previous classes. So we'll be looking at that. Legal professionals who are either unfamiliar or uncaring of how AAV can impact testimonies lead to unfair judgments. Linguistic discrimination against AAV speakers is still one of the few socially acceptable forms of discrimination, including affecting their credibility in court. And when we look at these implications, how it can reverberate through affecting verdicts and sentences, we can see how unfair the judicial process is when considering either witnesses or defendants using AAVE. In previous classes, we talked about Florida versus Zimmerman, the 2013 case where Rachel Gentile's testimony, her speech, her mannerisms were criticized and mocked by the media, and the jury said that they found, or at least reported it, that they found her difficult to understand and less credible due to the use of AAVE. And it illustrated how linguistic prejudice can affect juries' interpretation of truthfulness. There are other significant cases that we should discuss and look at. So the first being Hamilton versus Alabama, 1964. This case is important in that Mary Hamilton was a black civil rights activist, and she refused, she was not addressed by her surname in court. They repeatedly used her first name. And so this particular practice is not reserved for white individuals who are addressed with honorifics and their last name. This was specifically for black individuals. And so Hamilton refused to respond unless she was addressed respectfully as Miss Hamilton, and she was held in contempt of court for her refusal. The U.S. Supreme Court later ruled in favor of her, recognizing this form of address used in court form was a form of racial discrimination. And I think it highlights how it's not important what you say, but how you say it. This case illustrates how linguistic practices in the courtroom can reflect and perpetuate racial biases. Because of that, and what it seems is just as important, that what is left unsaid is important. It's precedence for linguistic equity and dignity, as the prosecution was trying to paint on already, or allude to a level of perception about what her standing was in the court by refusing to use any formality. You have the United States versus Arnold, 2007. In that was a police encounter where a witness exclaimed, "He fitting to shoot me," and the court had to determine whether this statement here was admissible under the excited utterance exception to the hearsay rule. And so the majority interpreted fitna as an extraction of fixing to or about to. So it indicated there was imminent action, thus admitting the statement. However, the dissenting parties argued that there was tense ambiguity and they questioned how it would be admissible in court. And so this shows you. This is a case that shows you how the courts can face challenges in misinterpreting AAVE terms, even including how that could influence evidentiary decisions. Louisiana versus Desmay, it was 2017, where Warren Desmay was interrogated by the police regarding sexual assault allegations. During the questioning, he stated, "If y'all think I did it, I know that I didn't do it, so why don't you just give me a lawyer, dog?" The Louisiana Supreme Court ruled that Desmay's references to a lawyer dog was too ambiguous and didn't constitute a clear request for legal counsel. And so, any subsequent requests that he made after that, or subsequent statements to the police, were all deemed admissible in court. In Desmay's case, it shows that the understanding of his vernacular speech resulted in continuation of an interrogation that should have stopped because there was no attorney present, compromising his Fifth and Sixth Amendment rights. His statement, if they had proceeded as an unambiguous invocation of requested counsel, would have protected him. And it is so showing that there is a legal necessity for proper training, proper awareness, so that misunderstandings will not influence verdicts, sentences, and lives. Furthermore, court reporters are typically certified at a 95 to a 98% accuracy level, depending on the organization that's certifying them. There was a study done in Philadelphia that revealed, this was 2019, that court reporters transcribing AAVE sentences had an accuracy average of 59.5%. That's significantly below any standard required for certification. Beyond just those areas, court reporters often struggle to paraphrase or fully even comprehend AAVE, and the study showed that the average comprehension rate was about 33%. And so you look at how these huge markers of inaccurate transcription can lead to misinterpretations of testimony, potentially affecting the outcome of trials, and then further undermining the fairness of the legal process. It can affect the integrity of any type of appellate court, because these erroneous transcriptions then hinder any meaningful appellate review, and appeals are often based on the official accurate record of a trial proceeding. So they're jeopardizing defendants' right to due process under the Fifth and 14th Amendments, because in addition to that, you see linguistic profiling being used to, influence jury decisions, jury selection, and then how they see the credibility or character of defendants or witnesses. Research indicates that speakers of AAVE are seen as less favorable in legal settings, and jurors, when rating AAVE speakers, found them to be less credible and more likely to be guilty compared to those using standard American English. And so addressing these biases is important because we have to look at how comprehensive education and awareness professionals, both for legal professionals, jury selection, can help increase the linguistic diversity of the courts and mitigate prejudice and promote fairness of all individuals regardless of their dialect. So one of the parts of doing this is recognizing and eliminating jury selection bias, because it helps prevent unfair trial outcomes. If we look at Flowers versus Mississippi, Curtis Flowers was an African American man who was tried 6 times for the same crime. It was a quadruple murder, 3 white people, 1 black person, and the prosecution repeatedly struck out black jurors to sit on the dais. And so for the first 3 convictions, the Mississippi Supreme Court cited prosecutorial misconduct as a reason for negating those convictions and remanding for a new trial. And so the first conviction was actually reversed because of the false statements made by the prosecutor that were used to mislead the jury. The second and third convictions involved Batson violations, and then the fourth and fifth ended in mistrials. Patson versus Kentucky in 1986 was a landmark Supreme Court case that established that preemptory challenges could not be used to systematically exclude jurors based on race. And so during the time when it came up before the Supreme Court, this is going to be the case for in Mississippi for looking at Flowers' convictions and having them overturned, you looked at the majority ruling. So that would be Justices Kavanaugh, Ginsburg, Breyer, Sotomayor, and Kagan and Alito supported the Batson challenge, stating that the prosecution had tried to mislead and control jury selection in order to not allow for due process, to not give Flowers, a jury of his peers. Clarence Thomas and Gorsuch said that they did not believe that the burden of proof was met. And Clarence Thomas actually took it a step further to say that he believed Batson versus Kentucky should be overruled. And that's a conversation for another day about where he stands with that. But what ended up happening is in September of 2020, the Mississippi State prosecutors dropped all charges against Flowers. Now, is that justice for the 4 murder victims? If he did do it, we'll never know because there was so much abuse and conflicts in the prosecution. It made it nearly impossible for them to convict Flowers with any type of, reasonable doubt. So, what we're looking at is when you have a jury that reflects the cultural diversity of a jury of his peers, then you avoid some of this bias and ambiguity that you can have, and it doesn't undermine due process. And that's why inclusive jury selection is going to be one of the major ways to combat this. But there are some other ways. We're going to look at some of the theories. In July 2023, Jamila Abdi was a 23-year-old black student from London that was charged with the Communications Act violation. Communications Act violation in 2003 for using the N-word, ending in A, in a tweet when referring to black footballer Alexander Isaac. And her legal team argued that this term is commonly used in AAVE and Black British English, which is a form of offshoot, and it's a form of reclamation and solidarity, and distinctive from the offensive slur that we know that ends in ER. And so, despite this, her tweet was flagged by the Data Monitoring Organization and referred to the Metropolitan Police, which then led to the Crown Prosecution Services to bring charges. This legal battle lasted over a year before they finally dropped the case due to insufficient evidence and understanding that any realistic process of conviction was going to be far off. But what this does highlight this case is that it is a misuse of hate speech laws to formally criminalize cultural expression within minority communities. And it also understood how important it is for linguistic nuances in legal interpretation and cultural context. Because had that existed, we wouldn't even have gotten to the point for a trial to be dragged out for over a year and a half. And these unjust prosecutions, I'm sure that there is a loss in character and credibility and time and money spent that she'll never get back just because of this. So it is a black bar. In addition to that, a study done in August 2024 revealed that AI models, such as what was used for the monitoring system, exhibits bias against speakers of AAVE. And so this is going to be that they are consistently, in AI systems, assigning speakers of AAVE to lower prestige jobs. They issued more convictions when running hypothetical criminal cases, including providing more instances of death penalties. The findings are concerning because AI is being deployed in both legal and employment contexts as we speak. And so it's a reflection of society, and with these increased biases now being implemented in the technology, it's going to perpetuate existing disparities. And so there's a need for developing AI to be more fair and unbiased, but it also is hard because the output is only going to be as good as the input. So, scholars have looked at how do you approach these process violations, such as, creating, I guess, a scholarship, it's called. And so in the legal setting, a scholarship for linguistic awareness means that we're going to be looking at legal training for professionals, incorporating linguistic expertise in court proceedings in order to mitigate these issues that we're discussing. However, with Project 2025, and the Trump administration, you see the execution of this comprehensive plan by the conservative think tanks to restructure the federal government in a way that will expand presidential authority and undermine civil rights protections. And this is going to disproportionately harm Black communities. So it is an uphill battle that we're looking at as they start to walk to dismantling the Department of Education, dismantling initiatives that promote anti-discrimination, eroding protections against racial discrimination in various sectors, and that's going to include the educational system, the legal system, the employment system. So if you analyze like the first 100 days that we're approaching right now, you look at reverses of decades of progress in civil rights, reducing political power, increasing economic disparities, and impacting educational access for Black Americans and people of color. In the early 2025, what was it, January, signed the executive order titled Ending Racial and Wasteful Government DEI Programs and Preferencing, stating that these DEI rollbacks were a way to impact the mandates that were aimed at promoting racial diversity within the federal workplace, stating that these initiatives were actually violations. And so the civil rights organizations such as the ACLU has called out that the fact that these rollbacks are a way for them to legally impose racial inequality and undermine civil rights. And it exacerbates the existing disparities we talked about, as well as hindering any type of way to address the systematic discrimination that we've done over the past 30, 40, 50 years. And so we have to understand that there's going to be a profound impact that will reverberate against communities that were looking for these sort of protections. And as we continue to progress and all these different rollouts to undermine DEI and to undermine, educational opportunities and employment practices. It is being fought in courts, but as I said, that's going to drag out. And when we look at how it's shaped to work against us already, I just, we can be we have to be very mindful of these little erosions that start. It's going to be a trickle down effect. And in addition, some of these cases are used to distract on bigger things that are happening on a global scale. And so that's very important to look at as well. So, what recommendations do we have to combat these attacks? Part of it is going to be policy reform to protect non standard English speakers, training programs, and legal educational initiatives. The American Association for Applied Linguistics has developed guidelines to improve communication of legal rights to non-native English speakers that includes other dialects. And these guidelines recommend rewording traditional legal phrases into clearer English or even their chosen dialects to enhance comprehension among individuals. And the Linguistic Society of America has also issued a statement that imposes the designation of English as official language of the United States, another one of the Trump initiatives to produce. Uh, to argue that these policies that he's promoting marginalize speakers of different languages and dialects, that includes AAVE, and thereby infringing upon their civil rights. Latham and Watkin offer an annual diversity and leadership academy. These type of initiatives are aimed at empowering law students and mid-level associates from diverse backgrounds to show they can develop their leadership skills, promote inclusivity within the legal profession, and help them over a semester-long course develop and educate future lawyers on DEI within the legal profession, and that would be the Institute for Inclusion in the Legal Profession. And so that course, along with some others like the ABE toolkit, are resources that are designated to or designed to facilitate these conversations regarding gender, race, ethnicity in the workplace, and materials that should be served as or used as guidelines for legal and professionals to improve workplace inclusivity and thus including and improving biases addressed concerns related to language and dialect in legal settings. So if you look at, for instance, PEMBE, which was co-founded by Harvard Law students, it's a nonprofit organization. It's focused on supporting students of African descent by helping them gain admission to and succeed in American law systems. Because as we flood the law systems with people that look like us, reflect us, and provide mentorship, resources, support networks, then we can start changing the tides on implementing these policy reforms and implementing these initiatives that are going to foster a more inclusive and diverse legal system. In once that's achieved, the fair treatment of speakers of all language varieties, including AAVE, can happen. Until then, until we incorporate diverse sources both behind the legal system, in front of it, and within it, then we're going to continue to face these injustices. And we're going to force, it's going to be hard to integrate perspectives to enrich, the experience of the legal system for our people. Addressing language bias in the legal system necessitates the application of theoretical frameworks that scrutinize the interplay between language, power, and societal structure. When we look at some of these key frameworks, such as CRT, which examines how law and legal institutions perpetuate racial inequalities. And it posits that these biases are related not only to just language, but are further embedded within the actual systematic discrimination in other systems, including the legal system, that is designed to hold down marginalized groups. When legal scholars and practitioners apply CRT, they can identify and challenge linguistic biases that disproportionately affect individuals based on race and ethnicity. Taking that one step further, looking at intersectionality developed by Kimberly Crenshaw, um, you look at how various social identities such as race, gender, class, language intersect to create these unique experiences of oppression or privilege. And in a legal context, this framework helps understand how these language biases are then intersected with other forms of discrimination to compound disadvantages on marginalized and multi-marginalized groups. Um, Social linguistics is the study of language and society, as we discussed in a previous class. And so it focuses on how language and variations within it function, how language varies and functions across different social contexts. And so when you apply that social linguistic theories to the legal system, you are able to recognize and value linguistic diversity and how non-standard dialects have these unmitigated biases against them that promote that dissuade fairer legal outcomes. And if you look at the implicit bias theory, that theory explores how these unconscious biases influence decision making. And so in the legal realm, they affect judgments about credibility and intelligence of the speaker's language or dialect. And these implicit biases are then, you know, reducing the progress of legal proceedings. And so the outcomes are tainted. By including them in developmental training, we can adjust for that and achieve procedural justice. Because procedural justice focuses on the fairness within the legal system and ensuring that, people are heard and respected in their own voices, mapped and shaped by their linguistic backgrounds, and it's a very central part of this theory. And so, in order to implement procedural justice, principals have to understand that they can be trusted. The justice principles have to be entrusted in the legal. I cannot speak, in the legal system at all aspects. So that means that the judges have to be diverse, the lawyers have to be diverse, the juries have to be diverse. One way to look at this and highlight that is through forensic linguistics, which looks at linguistic knowledge for legal issues such as analyzing courtroom discourse, looking at linguistic evidence from decisions, and seeing how they can uncover language biases in the legal setting and inform strategies to address them. So it'll take old court cases, it'll look at the legal education, it'll look at the policy making that drove it, and use these practices to combat linguistic bias and foster a more equitable language system. Okay, here I want to look at a few countries that have implemented some legal frameworks to help promote and protect linguistic diversity. So first, in Canada, they recognize both French and English as their official languages on the federal level, but on the provincial level, they have varying degrees of services in other languages that help accommodate their linguistic demographics. In South Africa, Their constitution acknowledges 11 official languages, including Afrikaans, English, Zulu, Xhosa, and so the recognition ensures that governmental and legal proceedings accommodate the country's linguistic diversity. In addition to that, the South African School Act allows for instruction in any of their official languages, which promotes mother tongue education. It promotes linguistic diversity from a very early age. If you look at the Finnish constitution, they grant equal status to Finnish and Swedish, which ensures that speakers and citizens of either can navigate the legal context, can navigate the educational system and public services. They have an indigenous group called the Sami, and they have the right to maintain and develop their own language and culture. And so when they are within their homelands, the Finnish law provides the use of their language in all official contexts. And so I think that is notable. Um, the Indian Constitution recognizes 22 languages, granting them official status in various regions. They also have a policy that ensures that legal proceedings, education, and public services can be conducted in any of these languages um, in individual states. In addition, they have authority and autonomy to adopt their own official languages based on regional linguistic demographics. And so that allows for a tailored approach to language and so that it can be used in their governance and law, something that we don't really see in America. And the EU supports linguistic diversity by recognizing 24 official languages made up of the members countries. And so for legal proceedings, for legislation, all member languages are used and are accessible. And so through programs like Erasmus Plus and Creative Europe, the European Union also funds projects that promote language learning and the preservation of these linguistic diversities across their member states. I know that we talked about a lot, but the motion sensor lights going off means that I probably should be getting out of here. So I will have the additional resources located on my website by Tuesday morning. I'm recording right now. It should be Sunday night. So give me about a day to get that all set. And it'll be adventuresinzen.com. You'll see the intro to AAVE. In addition, I am thinking about what to do for kind of like a summer class. We'll take maybe like a 2-week break and then break into something a little less formal. I think I wanted to cover maybe things you should know by 30, but I also want to hear input on what you guys would like to see or hear. Um, Obviously, I'll lead towards things that are more in my wheelhouse, but I take a very, holistic approach to learning, and I do like to read and stuff like that. So potentially, if it's something I don't know, we can learn together, and that can also be fun. But I do, like I said, I appreciate this Hillmantok community, and I'm just learning so much, and I want to continue to share my knowledge as well. On the next slide, you'll see my contact information. If you have any questions, as we already discussed, just feel free to hook me up. All right. And so that email is going to be books@adventuresinzen.com. Again, my website is www.adventuresinzen.com. Adventures in Zen Books on all social media. So feel free to reach out if you have any questions, if you have any concerns, comments, have any insight, input, or suggestions. As always, stay grounded, stay hydrated, stay kind.